Title VII makes it unlawful for an employer to discriminate on the basis of gender in any employment situation or opportunity. We now review some of the ways in which employers have engaged in gender-based discrimination. These include gender as the basis of an employment decision, gender plus discrimination, and sexual harassment. First, employers engage in gender discrimination when they use a person's gender as the basis for an employment decision. This form is the most straightforward and obvious way that gender discrimination occurs. The second form of gender discrimination occurs when an employee would have been treated differently if it had not been for that employee's gender. This form is known as gender plus discrimination. An employer who refuses to hire women with preschool-aged children but hires males with preschool-aged children is guilty of gender plus discrimination. The third form of gender discrimination is sexual harassment. Under Title VII, any form of gender discrimination is illegal, but in 1986, the Supreme Court ruled on a gender discrimination case. This case made it clear that creating a hostile work environment for someone because of their gender was also prohibited under Title VII and was considered sexual harassment. Keep in mind that sexual harassment can involve two members of the same gender. According to EEOC guidelines, sexual harassment includes, but is not limited to, the following: unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature when submission to such conduct is made either explicitly or implicitly as a term or condition of an individual's employment, submission to or rejection of such conduct by an individual is used as the basis for employment decisions affecting such individual, or such conduct has the purpose or effect of unreasonably interfering with the individual's work performance or creating an intimidating, hostile, or otherwise offensive working environment. The EEOC has identified two types of sexual harassment. The most straightforward type is called quid pro quo harassment. Quid pro quo means something for something, or this for that. When this type of harassment occurs, submission to sexual conduct is made explicitly or implicitly as a condition of employment. A manager might agree to give an employee a raise or a promotion in exchange for her going out on a date with him. No date, no raise. The manager's request constitutes quid pro quo sexual harassment. The other form of sexual harassment is referred to as hostile work environment sexual harassment. Hostile work environment harassment is quite controversial in some instances and more straightforward in others. The challenge arises because what may not appear to be a hostile work environment to one person may appear to be to another. Some people are offended by jokes with sexual overtones, while others are not. Whether or not employees might be offended, the jokes do not belong in the workplace. Managers have an obligation to take corrective action once they are informed of a potential sexual harassment situation. According to the EEOC, a company may be guilty of harassment if the company knew or should have known about the harassment. A manager who ignores a complaint is allowing the climate to exist that's offensive to an employee in the work unit. If the employee pursues action through the EEOC or through the courts, the question becomes whether there's a pattern of such behavior in the firm's workplace and whether a reasonable person would find the behaviors offensive. In sexual harassment cases in which the victim of harassment complains to management and nothing is done, or management should have known about the problem even if the victim did not speak up, the victim will have a better chance of winning the case. Therefore, it is important for managers to act quickly and decisively when any suggestion of sexual harassment occurs. Managers are agents of the company and put the company at risk if they are the harassers, or if they fail to take complaints seriously, or their employees tell them about possible sexual harassment incidents. The EEOC and the courts generally respond more favorably to employers who have clearly communicated to employees that behavior of a sexual nature is not welcome in the workplace. Also, employers can improve their chances of defending a case brought against them by showing that the plaintiff did not take advantage of corrective and preventative opportunities offered by the employer. If the company can prove that the incident was never reported, even though the company had a clearly defined complaint process, the company will have a better chance of defending its lack of responsiveness. The EEOC has clearly articulated basic guidelines for employers to follow to reduce the incidence of sexual harassment in the workplace.